Hi everyone, I am Suyash and today I will talk about the case of Manmohan Nanda versus United India Assurance Company Limited and another. Wherein the Honorable Supreme Court inter alia discussed the doctrine of contra proferentum in the field of statutory interpretation and insurance contracts. To know more about insurance contracts, please visit my earlier show, the link for which is provided in the description below. Contra proferentum is a Latin term that literally means against the offerer, and it is also a legal doctrine that stipulates that in interpreting documents, ambiguities are to be construed unfavorably to the drafter. Basically, when words are to be construed, resulting in two alternative interpretations, then the interpretation which is against the person using or drafting the words or expressions which have given rise to the difficulty in construction applies. The contra proferentum rule is mostly invoked in standard form of contracts, as such contracts heavily comprise of forms with printed terms which are invariably used for the same kind of contracts. Further, it has also been noticed that in today's world that is dominated by corporate entities, the standard form contracts are harshly worded against individuals. While entering into such contracts, the individuals often do not read and understand the provisions, resulting in grave legal implications later on. It is also pertinent that when such standard form contracts ordinarily contain exception clauses, they are invariably construed contra proferentum against the person who has drafted the same. Moreover, in construing a document, one must have regard not to the presumed intention of the parties, but to the meaning of the words they have used. If two interpretations of the document are possible, the one which would give effect and meaning to all its parts should be adopted, and for the purpose, the words creating uncertainty in the document can be ignored. Thus, where there is an ambiguity, it is the duty of the court to look at all the parts of the document to ascertain what was really intended by the parties. In the present case, the court invoked the contra proferentum rule in relation to a contract of insurance, that is also a standard form contract, and it was noted that where there is an ambiguity or doubt in the contract of insurance, it has to be construed contra proferentum against the insurance company. The court also cited Hillsbury's Laws of England on the contra proferentum rule and stated that where there is ambiguity in the policy, the court will apply the contra proferentum rule. Where a policy is produced by the insurers, it is their business to see that precision and clarity are attained, and if they fail to do so, the ambiguity will be resolved by adopting the construction favorable to the insured. Similarly, when the insured fills up the proposal form or the application form, the language used in such proposal or application is to be interpreted in a manner that is favorable to the insurers if the insured has created any ambiguity. The court also cautioned that the contra proferentum rule becomes operative only where the words are truly ambiguous, since it is a rule for resolving ambiguity and it cannot be invoked with a view to creating a doubt. Therefore, where the words used are free from ambiguity in the sense that, fairly and reasonably construed, they admit of only one meaning, the rule has no application. Thus, the words should receive their ordinary and natural meaning unless that is displaced by a real ambiguity either appearing on the face of the policy or possibly by extrinsic evidence of surrounding circumstances. Therefore, in conclusion, the following pertinent points emerge. A. Contra proferentum means that in interpreting documents, ambiguities are to be construed unfavorably to the drafter. B. The contra proferentum rule is mostly invoked in standard form of contracts. C. When such standard form contracts ordinarily contain exception clauses, they are invariably construed contra proferentum against the person who has drafted the same. D. Where there is an ambiguity or doubt in the contract of insurance, it has to be construed contra proferentum against the insurance company. E. Similarly, an interpretation favorable to the insurers will prevail if the insured has created any ambiguity while filling up the insurance proposal or application. F. It is a rule for resolving ambiguity and it cannot be invoked with a view to creating a doubt. And G. The words should receive their ordinary and natural meaning unless that is displaced by a real ambiguity. Thus, I hope that the meaning and the nature of the doctrine of contra proferentum is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.